Welcome to the Supreme Court of Yukon Guide to Family Law Case Conferences. This video will show you what to expect at a family law case conference. What is a family law case conference, and how do I prepare? If you are involved in a family law court matter, one of the first things you will do is attend a family law case conference. It is required in most family law cases. This conference is an informal meeting that happens early on in your case. It includes you, the other party involved in your case, and a judge. If the other party has a lawyer, the lawyer may also attend. Even though a judge is present, a case conference is less formal than a court hearing. The formal rules of court do not apply, and there are no affidavit or sworn witness testimonies. The goal of the case conference is to help everyone understand the process, to simplify the case, and to explore ways to resolve things without going to court. It is a chance to have a conversation about your case with the judge. One of the parties must schedule a conference within 60 days of the statement of claim being served. Either party can schedule a time by contacting the Supreme Court trial coordinator. If you don't schedule a case conference, your case may be delayed. Before the conference, you should think about the issues in dispute between you and the other party, your position on these issues, which issues are most important to you, and what areas you could compromise on. You and the other party must prepare a simple pre-conference memorandum and file it with the court at least 3 business days before the conference. The memorandum must be signed by both parties or their lawyers. It sets out the issues you want to discuss, any attempts at settling the issues, and other important information. You can find the memorandum on the Yukon Court's website. Under Supreme Court Practice Direction, Family 3A. Or you can contact the trial coordinator for a copy. The judge will review the memorandum before the conference. How do I get to a family law case conference? If you live within 30 kilometers of Whitehorse, you must attend the conference in person. Otherwise, you may ask to attend by video or, as a last resort, by phone. Family law case conferences are usually held in the Supreme Court boardroom. Occasionally, they are held in a courtroom. On the day of the conference, check the court schedule posted on white paper on the wall near the fish pond to see the location. Make sure to bring all important documents with you, such as the pre-conference memorandum, the statement of claim and statement of defense. You should also bring a pen and paper to write notes. The Supreme Court boardroom is located on the 2nd floor of the courthouse. When you arrive at the courthouse, you can take the stairs to the 2nd floor or the elevator beside the court registry. At the top of the stairs, turn right, or when you get off the elevator, turn left. Go to the end of the hall. There you will see a door with a sign saying Supreme Court Boardroom. Wait outside this door for the judicial assistant to bring you in. In the boardroom, sit in a chair on one side of the table. The other party will sit across from you, and the judge will sit at the head of the table. Once the parties have arrived, the judge will be called to the boardroom. Everything said at the case conference is recorded, but the recording is not public and stays with the judge. The recording cannot be used as evidence in future court proceedings. It is there to clarify any misunderstandings about what was said at the conference. What happens at a family law case conference? The judge will start the conversation. They will encourage discussion between you and the other party about the issues in dispute and your positions on these issues. You are welcome to ask questions at any time throughout the conference. The judge may explain general legal principles relevant to your case, such as custody, parenting time, child support, or property division. The judge will explain the options available to help resolve your case outside of court, such as mediation or judicial settlement conferences. They will also explain the court process. The judge cannot give you legal advice, but can answer general questions. In some cases, the judge will make orders for financial disclosure or preserving assets. They may also recommend a child lawyer. The judge will usually make orders on significant issues such as parenting time or property division only if both parties agree. The judge may encourage you to participate in the free parenting and communication workshops offered through the Family Law Information Center. 3 workshops are available. 1. For the sake of the children. 2. Communication skills after separation or divorce. And 3. Managing conflict after separation or divorce. Throughout the conference, the judge will try to help you find areas of agreement, prioritize the issues, simplify them, or even resolve them. If your case can't be resolved at the conference, the judge may recommend a settlement process, or schedule your case for a future case conference or a court application. What happens after a family law case conferences? After the case conference, the judge will prepare a post-conference memorandum that summarizes what was discussed and any directions or orders made by the judge. You will receive a copy of any document arising from the case conference. Make sure to follow any directions or orders that are set out in these documents. You can schedule another family law case conference at any time if there are things you would like to discuss with the other party in the presence of the judge. Now you know what to expect at a family law case conference. Thank you for watching.